Now, as the Supreme Court judgment and the leadership tussle of the Labour Party remains a bone of contention, I am now joined by two lawyers, Tunji Abdulahmed and also Mawah Monday, to take it, or rather to make it make sense. Thank you very much, gentlemen, for joining us this evening. Now, I'm going to go right ahead and... Oh, you're welcome. Thank you very much.
Thank you for having me.
Rand. So Tunji, let's start by asking you, what was your initial reaction to the Supreme Court's judgment on the Labour Party's leadership tussle? And if you can, please, could you walk us through the key points of the judgment and how they relate to the Labour Party's constitution?
Yeah, thank you for having me. The judgment of the Supreme Court, what is clear from the judgment is that the Supreme Court did not look into the merit of the case. They did not consider the cases, the merit or otherwise of the case before them. What the Supreme Court heard was that the lower court, that is the Federal High Court, and the Court of Appeal have no jurisdiction to entertain the matter in the first instance on the ground that the matter is internal leadership of the party. And they are saying that whatever that is internal leadership of the party is not a matter for the court to decide. That it should be a matter for the party to treat. So what is clear from the judgment, again, is that Mr. Abure chairmanship of the party, or confirmation of his chairmanship of the party by the Court of Appeal was set aside. In other words, the Court of Appeal decision that made him, the chairman of the party, has been said to be set aside, which means that no judgment exists for him to rely on. What is also clear from the judgment is that the court did not pronounce Nanadi Usman as the authentic chairman or whatever chairman of the party. Nobody has been confirmed as in that regard by the Supreme Court, because they did not look into the merit of the case. They only determined the jurisdiction, because in law, when the court don't have jurisdiction, you can, no matter what you do, no matter how good that thing is, it is illegal, it is nullity. So a court must have jurisdiction for it to be able to entertain the matter. But for me, I think Supreme Court, being a court of policy, should go further, because I'm aware that Supreme Court advised the party to always abide by their constitution, and they should reduce the attitude of coming to court to help them resolve their matters. Okay. You see, we are in a country where people don't play by the rules because of their selfish interests. So I expect that, look, Supreme Court will not only rely on technicality of lack of jurisdiction. Once the matter gets to the Supreme Court, I am thinking that Supreme Court should find it more important to look at the merit of the case, so that to set it as to kill the case entirely. Because not looking at the case today is the reason why we're having what we're having today now. And okay. I tell you, the advice of the Supreme Court that they should allow constitution of the party to prevail may not hold water, because these people are not ready to abide by it. So when there's a dispute between two people and they are not able to come together, the only place they can go is the court. So I think the issue of a court will not intervene in the affairs of the internal affairs of the party should not be a standard that would at appropriate situation. Okay, then, the court should engage.
All right, then, All right, let me come to Mr. Mawah now. Mr. Mawah, some lawyers have argued that a return to status quo ruling is always a dicey one, especially in a case where the Supreme Court has restrained itself from naming the characters involved. Is this also your view?
Yes, honestly, I have that same view, and I think I shared it in a particular radio television station sometime late last week. Well, to be sincere, I think what the Supreme Court did is consistent with their position for quite some time now, when it borders on party politics and leadership in any political party. And the rationale behind that is that the Supreme Court are of the opinion that membership of political party is voluntarily, and that once you have decided to join any party, you have automatically also decided to abide by its constitution. And like my brother there stated earlier on, the point is the politicians for whom they are not known to play by the rule. They are not known to play by the They are not known to play by the rules of the game. And so, if we say, let them do whatever they are supposed to do, politicians will not do what is right, with the greatest respect to all of them. And so, I think it is about time the Supreme Court now decided to take a second look at its position that party leadership matter, that it will not dabble into it. Because if you don't dabble into it, these guys will not be able to settle themselves. Now, for instance, look at the present situation in Labour Party at the moment. Yes, the Supreme Court, by that decision, clearly sacked Abure. Unfortunately, and contrary to the position being speculated by some person on the other angle, the Supreme Court, by that judgment, did not return or confirmed Nenadi Usman. Because if you look at the notice of appeal that Nenadi Usman filed before the Supreme Court, which is the originating process, they asked for two reliefs. The first relief was another allowing her appeal. That was the first order. Then the second order was an order setting aside the decision of the both lower court, that is the Federal High Court and the Court of Appeal, that affirmed Abure as the national chairman. And the Supreme Court clearly granted those two reliefs and did not go beyond that. Because don't forget, the court is not a Father Christmas. The court can only grant whatever you have decided to ask from the court, which is in consonance with your pleadings or the affidavit in support of your case. But they cannot go outside that. Now, I listened to Senator Ume this evening, I think on our right television, and his position, with the greatest respect to him, was that, if two people went to court and one lost out, that the other person automatically has won. But that is not the case all the time. For instance, if both of us we go to court now over a dispute related to land, and I am the claimant, I went to court seeking for declaration in respect of maybe 2 parcels of land against you, and what you just merely did was to file your statement of defense without more. If at the end of the case the court found that I have not been able to establish my case, the court will dismiss my claim. So for the fact that the court has dismissed my claim does not automatically mean that the court has awarded the land to you, the defendant, unless you have what we call counterclaim. So in other words, beyond you filing just statement of defense, you must file a counterclaim. And in your counterclaim, you must have been able to show how you have a superior right or superior title to that land better than myself. So without a counterclaim, you cannot say you have gotten the judgment which is in your favor. I think that the position taken by the senator was
Mr. Mawah, the situation leaves much to interpretation and very diverse interpretation. Tunji, I will come to you in just a minute, but I still have another question for Mr. Mawah here with us. Let's take a look at the arguments presented by both sides now. What were the strongest arguments, Mr. Mawah, that both sides actually presented in their cases?
I didn't get that. Please, can you come again? I didn't get that.
What were the strongest arguments, in your view, presented by the sides in their cases?
You mean in their cases before the court?
Yes.
Yes. No, I think the position was that, don't forget, what gave rise to this case we are talking about was that a result of Abure Convention, which took place sometime last year in March in Unewi. When Abure conducted that convention, he wrote a letter to INEC, giving INEC the statutory 21 days notice to convoke that convention. Now, INEC did not attend the convention, and some other stakeholders in Labour Party, including Alex Oti, the governor of Abia State, and His Excellency Peter Obi, they did not attend. So at the end of the convention, Abure and his group returned themselves as elected, and then they submitted the outcome to INEC. But INEC refused to accept them. And as a result, Abure was refused entrance into some of the quarterly meeting of INEC. And as a result of that, Abure, the Labour Party approached the court, asking the court that, in view of the fact that, is it right for INEC to refuse Abure entrance into the INEC meeting as a job simply because they did not attend the convention of INEC, Abure? And the court, that was the question of the Labour Party before the court. Now, when that matter was going, Nenadi and her group brought an application to be joined as an interested party, and they were joined. Now, as soon as they got in there, they brought in issue of leadership to the suit. They were the one that introduced issue of leadership to the suit. And so they canvassed the fact that Abure tenure has expired. And that at the time Abure went to convoke or conduct that convention, that he was no longer having the capacity legally to convoke that. And the Federal High Court, presided over by Honorable Justice Omotosho, agreed with Abure and ordered INEC to recognize Abure. And that matter was appealed to Court of Appeal. Court of Appeal affirmed the judgment of Justice Omotosho. Unfortunately, Supreme Court set aside those decisions just last week. And I think the position both of them made was that none of them, Nenadi claimed he's the leader of the party, having been constituted in Abia State. Unfortunately, there is another problem to that fact. Because Section 223 of the Constitution does not allow for the party administration to be administered by a critical committee.
Right.
In other words, critical committee is not known to our Constitution.
Monday, we are running out of time, and I do have a question, my last question here from Mr. Tunji. Mr. Tunji, I have saved the best question for you. A party at the precipice of actually falling apart at the center here, what steps do you think the Labour Party should take in response to the judgment to ensure a smooth transition and also maintain party unity?
I think what they did today, by calling a meeting of all board members of the party and stakeholders of the party, is the appropriate thing to do so as to make a way forward. Because as it is today now, there is a vacuum as regards the chairmanship of the party. The court has clearly sacked Mr. Abure, and the tenure of other members of the leadership, I think it has expired. So what they need to do is to come together, decide on the way forward, which is what they did today at the party. But because some people are not interested in that, they refuse to attend, and they were making declarations from where they are. Like, for example, Mr. Lamidi Ababa is declaring himself as the chairman of the party. Let them assume there's a vacancy, and there's a need to fill that vacancy. Will it be you that will come up and announce yourself the party must come together and decide to say, look, in view of this vacancy or whatever has happened, this is what the way to go. And that's what they are doing today. And I think they have done the right thing by calling the meeting of all parties. That is the way forward, as far as I'm concerned.
A very interesting take there, Tunji. Thank you very much, Mr. Tunji Abdulahmed, and also thank you very much, Mawah, for joining us to give us your views on the matter. Thank you, gentlemen.